Richard Prosser.
Mr Speaker, I'm pleased to rise on behalf of New Zealand First to take a call on this first reading of the Agricultural Compounds and Veterinary Medicines Amendment Bill. New Zealand First supports this bill, certainly to the Select Committee and probably beyond. And I say probably, Mr Speaker, because our position is only likely to change if, on closer examination, we discover that there are any fishhooks in it. And, Mr Speaker, I would like to make reference to my erstwhile colleague, Mr Bailey there, who, in his previous speech, in that wonderfully gravelly baritone that he's blessed with, said that he was surprised that New Zealand First was supporting a government bill. Well, Mr Bailey, when some more time has passed, you'll be aware that New Zealand First actually does support probably about half and half of government bills. So about half we support, about half we oppose. And it's probably the only real objective measure that the government has for assessing whether or not its own bills are good bills or not, because if New Zealand First supports them, they're good bills. So take that as a rule of thumb, Mr Bailey. So I am looking forward to examining this bill in Select Committee, Mr Speaker, and I'm sure that in committee under the most able and it has to be said, affable chairmanship of Mr McKelvey, we will discover any such faults or pitfalls as might be lurking within it. Mr Speaker, the bill itself is largely technical in nature, which is perhaps unsurprising given that it is an amendment bill which changes some technical aspects of the Principal Act and doesn't appear to do a great deal else other than perhaps bringing it up to date. At face value, it seems that extending the protection of confidential information given in support of applications to register innovative trade name products from 5 years to 8 years is eminently sensible, Mr Speaker, in this day and age where communication is instantaneous, where manufacturing is global, where competition is cutthroat, where the vultures are circling, if you like, with regards to firms looking to profit from the advances made possible by the efforts and the researches of others. It makes sense to extend the protections that are currently afforded to the owners and developers of intellectual property for them to be allowed to benefit the most from the products and ingredients that they have developed and invented. And in terms of further applications and uses that might not have been thought of, that might not have been technologically possible for other reasons at the time a particular product was developed, or in fact that the person or the firm who developed a unique or innovative compound might not have been in a financial position to further develop its uses. It makes sense for people in those cases to be allowed some further protection in terms of the confidentiality of the IP that they bring in support of their applications. And it may be, in fact, that submitters to the Select Committee might suggest that, in fact, a 3-year extension is insufficient. In fact, submitters might suggest all manner of things, Mr Speaker, and that alone would be a reason enough for any party to support this bill to the Select Committee through its first reading. I do note, however, from the regulatory impact statement that MPI do not appear to necessarily share that particular sentiment, Mr Speaker, and in fact they state, and I quote, "There is no compelling reason to increase the basic length of the data protection term for innovative compounds, principally due to the interface with the patent system." They do go on to say, that, I quote, "However, the ability to extend the length of the data protection period for the original product if extra uses are added may provide an incentive to add minor uses to labels, which is a particular issue for New Zealand." And it might, Mr Speaker, but I might venture to suggest that perhaps the inability to find a compelling reason for extending the protection of someone's hard-earned intellectual property is perhaps the hallmark of a department that has never created such intellectual property. And I wonder if perhaps we have the Minister to thank for the fact that this provision has made it this far at all. It would certainly do the Minister credit if that were the case, Mr Speaker. And if that is indeed the case, then I do hold great hope for the success of the Select Committee process, because it would appear to indicate that the government certainly desires to be on the side of the angels with regards to this particular matter. And if they are, Mr Speaker, then New Zealand First will be only too pleased to be there alongside them. Mr Speaker, this is a first reading of a bill which does not appear to show signs of being particularly controversial, notwithstanding the comments from my erstwhile colleague from the Greens. And as I have indicated, New Zealand First will support it to Select Committee and in all probability beyond. I will sit on the committee, that fine, august body of men and women, as we examine it, and for those reasons I do not intend to take too much of the House's time at this stage. If we have any questions at this stage, Mr Speaker, it's probably these. They come from the Departmental Disclosure Statement, and the first is in Part 3, Testing of Legislative Content, and here at subsection 3.2, the Department asks itself, and I quote, "What steps have been taken to determine whether the policy to be given effect by this bill is consistent with the principles of the Treaty of Waitangi?" To which the Department answers itself with the following: MPI has assessed the proposals against the principles of Te Tiriti o Waitangi and consulted Te Puni Koukiri. MPI's assessment is that the policy does not appear to be inconsistent with the principles of Te Tiriti o Waitangi, which is all well and good, Mr Speaker, and very probably as it should be, but I do have to ask, and maybe this is not the best forum to ask in, but opportunities for doing so are few and far between, and the department obviously considers it pertinent to the bill. So I have to ask, Mr Speaker, if the department has come to the conclusion that this bill does not appear to be inconsistent with the principles of the treaty, then one could be forgiven, I believe, for presuming that the department has some understanding as to what those principles actually are. And if it does, perhaps it could share those with the House, because nobody else seems to know. The second is in Part 4, under the heading Significant Legislative Features. And at 4.4a, the question as to whether the bill creates or amends a strict liability offence is answered with a resounding no. And I have to ask, why not, Mr Speaker? Surely if we are enacting a piece of legislation which is intended to protect someone's rights or property, then we must, I would have thought, also be intending that a breach of those rights would constitute an offence of some sort. And maybe the Minister would care to comment on that. The only other question I have at this stage, Mr Speaker, is a query that was raised by a colleague earlier in the process, and that relates to whether or not the provisions in this bill are to extend to products or substances coming into New Zealand, as well as those which are developed here. The reason behind the question being a concern as to whether this bill might in fact mean that innovative products developed by overseas companies or persons may remain unnecessarily expensive to New Zealand companies or consumers relative to their cost in other jurisdictions. And perhaps the Minister might like to make some comment on that. But in closing, Mr Speaker, I say again that New Zealand First will support this bill, at least to the Select Committee, very probably beyond. The stated intention appears to be eminently sensible and well-intentioned, and I look forward to examining it in further detail through the committee process. Thank you.